Welcome to your key discovery point. I am Brett Burney from Nextpoint, joined by Doug Austin of eDiscovery today. Doug, this week you posted about a case where one party used TAR, more specifically CAL, continuous active learning, to create a production set. They use these technologies to identify supposedly relevant documents that they would produce. But it didn't go so well. The other party obviously took issue with that. This case has actually been going on for several years. You've actually covered it before, I think about a year, almost 2 years ago now. And you wrote about it when the court appointed a special master, Mara Grossman. And it's just been interesting to kind of watch this case from that point going forward.
Yes, it is. It has been. And I actually forgot that I had covered it in 2023 when the preliminary diagnostic protocol had been implemented by Special Master Grossman. But
Right.
this is, to me, one of the things that I think about with this case is what Judge Peck said way back in the De Silva Moore ruling when he said, TAR is not a Staples easy button. And
Right.
this case illustrates it. We had the case years ago that involved the airlines, that involved hundreds of thousands of non-relevant documents produced. This one was the other direction, where the initial plaintiffs initially produced fewer than 18,000 documents. And by the way, they said, the ruling said a TAR-CAL approach, but as a colleague of mine, Jeremy
Pickens?
Jeremy Pickens, Dr. J.
Yep.
Sorry, I keep
That's
blanking
okay.
on his last name. Pointed out, they talked about documents not meeting their 64-point threshold, which sounds more like a TAR 1 than a TAR 2 approach. So hard to be quite clear exactly what was going on there. Regardless, Walgreens said, "Hey, wait a minute. We've got a similar case, litigation with CVS, and plaintiffs produced 140,000 responsive documents in that case. There's got to be more than 18,000."
Right.
And eventually, initial plaintiffs produced over 280,000 additional documents, so more than 10 times as much as the initial production. But it still wasn't quite right. And there were the dispute raged on, got into motions to compel. Ultimately, Special Master Grossman was appointed. She conducted a preliminary diagnostic protocol, which basically was devised back in July of 2023. And then she ultimately identifying a huge discrepancy between the documents produced and the documents that were actually responsive. She said she basically devised a remediation protocol, which has taken several months to undertake, and ultimately resulted in another 77,000 additional responsive documents. So more than 350,000 documents produced after the production was declared substantially complete.
That was the big thing that came out of that. It's like at the very beginning, but just those 18,000, the plaintiffs here, the initial plaintiffs, represented to the court and to the opposing party, to Walgreens, that the productions were, quote, substantially complete. And then when Special Master Grossman got involved, she said, her quote was, how plaintiffs could possibly have declared the original production substantially complete under the circumstances is just beyond her. Like, it was just pretty... it was pretty black and white here. Like, something wasn't working correctly. And obviously we don't know some of the backstory. They appeared to have a very good vendor working with them. But I think it's exactly what you were just talking about, Doug. It's not always sort of the easy button. Like, it's not something you just got to throw in and are saying, and, trust that the process is always going to work. I mean, every case is a little bit different. And maybe it's important to make sure you've got some kind of a specialist or an expert that can at least guide you, at least initially, through some of these things. And maybe something like this wouldn't happen. No guarantees, but it's always better to be safer if you can.
Yeah, I definitely see this as not a technology problem, but a process problem.
Yeah,
It's how the technology is being used, and in this case, I think there was clearly a flaw in the approach, which certainly the protocols that Special Master Grossman came up with, flushed out, and ultimately Walgreens requested a bunch of sanctions.
right,
The one that they got, which was significant, and I suspect will be, I think they requested millions, but certainly I think they'll at least get hundreds of thousands, was basically fees and costs under Rule 37A5A.
yeah,
Judge Kendall in the case pointed out that the plaintiffs didn't really make an argument against sanctions under that rule.
right,
So she granted the Walgreens request for an award of expenses and attorney's fees. She didn't grant the other significant sanctions dismissal, preclusion of initial plaintiffs obtaining damages and costs, adverse jury instructions, all that. Ultimately, this ruling also involved initial plaintiff's motion for sanctions, where they alleged Walgreens manipulated the special master process to its benefit. And Judge Kendall pointed out that the initial plaintiffs participated in the drafting of the remediation protocol and refused and
right,
basically said the court cannot and will not issue sanctions just because initial plaintiffs do not like the outcome of a remediation process that was only necessitated by their own discovery failures.
right,
I think that pretty much says it all in terms of their attempt to get their own sanctions. Yeah,
yeah.
this definitely illustrates that just simply conducting a TAR process is not a slam dunk, and it can go terribly wrong if you don't have a sound process in place.
Yeah, and it's not so much the technology, right? I just wanted to underscore that. Like, this is nothing in here, or pretty much any case we've seen, like, says that you can't use tar, or that it's not necessarily going to be supportive. But if you're going to use it, regardless of what tool that you use, just make sure you're dotting all the I's and crossing all the T's on some of this. And if you're going to say it's complete as far as your production, just make sure it is complete. And that's no different, right? That's a rubric we've lived under for many, many years in this profession. But it can get scary and kind of come back and kick you in the wrong side at times.
Sure. Yeah. And I mean, obviously, I don't know the details about the process here, but it seems like a reasonable sample of the null set would have potentially fleshed
Yeah,
out that they were under inclusive in their
right,
production, especially
right.
considering just how far off they were. So, that's definitely a key. It's one thing to have the technology in place, but it's also
Yeah.
understanding how to use it, and this whole concern about yeah, the technology advances, getting rid of humans. Humans have to be in the loop, and they have to be
Right.
managing it properly.
Yeah, and just like you said, like somebody had looked at that null set. But to be fair, if you don't do this a whole lot, if you're not working on a bunch of matters that involve tar technology or Cal, you may not know that that's something that you're going to look at. So good stuff there. We are actually going to be together again in a few weeks here, Doug, on a webinar with EDRM and Nextpoint. I'm really looking forward to this. It's called Truth on Trial: How to Detect and Challenge Deepfake Evidence in the AI Era. We've got Judge Rodriguez on. We've got Dr. Felix Hernandez to help us kind of understand some of the technology side of this. But looking forward to this. You covered it just a couple of days ago as well. So I'm going to make sure that link is in the show notes. So if you are out there and looking to get a little bit of help with detecting deepfake evidence, this will be worth a few minutes of your time on January 2nd, 2026.
January 22nd. Yes.
Yeah, very
You
good.
said January 2nd. So
Yeah,
yes, I'm
22nd.
I'm
Sorry,
yeah,
22nd.
yeah. Well, I'll just say that was a deep fake. So, but no, this is going to be a fun one. We're really going to talk about. I mean, you've got obviously Judge Rodriguez to talk about the legal, considerations. Dr.
Yes.
Hernandez to talk about the technical stuff. So you've got a legal expert, a technical expert, and me. So hopefully I'll contribute something in there.
Oh,
And
yeah.
I think it'll be a very fun discussion.
That's coming up in just a few weeks, but we'll talk with you before then, Doug. Always look forward to all of your posts. And thanks again. We'll talk with you soon.
All right. Thanks, Brett. Thanks, everybody.